Thank you again for everyone being here. And you are going to learn a whole bunch today in this segment that we call Supporting Seniors. Some of you here may have heard me talk about this in other presentations in the past, but it's going to be different. So why is it different? Because the laws change, and there's a big change in the law as of last month. Many of you know the One Big Beautiful Bill Act changes a lot in the scope of lots of different areas of the law and lots of different areas of the law that we're involved with, and that affects seniors. So we're going to touch on that, of course, and there's some other things that have changed too. So this is an evolving conversation, much like estate planning in general, or just planning for your future, because life's evolving. So this conversation evolves with life and the change in the laws. So always something new to learn and teach and talk about. So without further ado, let's get into it because there's some good things here. So this is a little bit more about me. For those of you who don't know who I am, this is a little bit more about what I'm about. A lot of words on the screen. It just means that I've lived 46 years and I've been able to fill that time by doing stuff. Some stuff is school, some stuff is practice. It'll be 20 years of me being in practice in December. Time goes by quickly. And then near and dear to my heart is being a man for others in the Jesuit tradition and being out in the community and helping the community. So really like that here, just not me, but our entire team at Snyder Law. It's something that's really important to us. So um, and of course, I do this because I have a family. And when we're talking about seniors, as you can see in the pictures here, some seniors on the board here. My parents, who are up in the top right in front of the universal globe, that's my mom and dad. My dad has Parkinson's, and he's an Army veteran from the 60s. So for me personally, my story as an adult child is I want to make sure that my dad, and of course my mom too, are well protected as they age, and we want them to age with dignity. And there's a lot of different aspects of that. Some of you who might be attending this webinar or watching it later, you do that for a profession, and just in a different sense, in a different angle. So for me here with what we're going to talk about today are all things that I think about when I'm thinking about those two wonderful parents there on the screen. So today what we're going to talk about specifically, what you're going to learn are some legal solutions for diminished capacity, diminished capacity. So when we have clients or people in our lives, family members that no longer are firing on all cylinders, whether they have a diagnosis or not yet, but they're being more forgetful or they're having some difficulty with executive functioning. When you get in the car with them, you're holding on for dear life. They're falling a lot. Things that are going on with their brain, things that aren't working like they used to work. We need to talk about some of the ramifications of that and some of the legal solutions for getting in front of some of the problems. Now, for those of you that are familiar with the One Big Beautiful Bill Act, you know that Medicaid cuts are very much a center portion of the conversation ongoing about that bill and its impacts. And it does impact seniors. So we're going to talk about the updates to Medi-Cal, which is California's Medicaid program, and how that impacts others, and things that will be important for you to know about for your loved ones. And then for those of us like me who have veterans in their life or spouses of veterans, it's going to be essential to learn a little bit more about the benefits that are available to those seniors that will improve the quality of their life. A lot of things that they might not even realize. So first, we're going to, in talking about diminished capacity, or how do we know when one of our parents or loved ones, a client, how do we know when that person no longer has the ability to legally make decisions for themselves? You know, a lot of that is subjective, right? So our viewpoint, okay, well, dad's not firing on all cylinders. Dad's not acting like he used to act. He used to be able to do this, now he can't do that. He's taken a long time to answer a question. He stares off into space, I can't understand it when he talks. He's slurring his words. These are all things that come up and are like little red flags or stick out in our mind going, I'm really questioning whether or not that my loved one is really has the capacity to be making decisions. And then there's some other circumstantial evidence, like we see the dents and dings on the car, or we see a stack of bills, or all of a sudden mom and dad are getting notices that they're in foreclosure, or they're shutting off power to the house because they haven't paid the bills because they've forgotten, or they just don't have the wherewithal to deal with it or want to deal with it. They're becoming more reclusive. They're not taking care of themselves. They look unkempt, right? Dad hasn't shaved in a week. That's not like him. Things like that, or they're becoming their attitudes. They're becoming a little more aggressive, snippy. Their lack of sleep. They seem more jittery or anxious or depressed. Those are all things in hallmark. So just look at, oh, and I put example of stove, increased forgetfulness. How can I forget this? The common, hey, that my mom or dad or aunt, uncle, they're not turning off the stove. They're turning it on and not shutting it off. An actual problem, as you know, that has some dire consequences for some when we're talking about gas stoves. So that could be a real hazard. But is that normal? I mean, does dad always forget? Like, there's a running joke in my family that I just get distracted and I forget to turn off the stove after I'm done making some eggs for breakfast. Well, that's normal for dad to do that. It has nothing to do with cognition. But is it not normal? Is that happening? And is it hazardous? Those are things that we want to take a look at. So for me, when we're working with clients or a family comes in, because usually the call is this. Phone call comes in and says, you know what, I'm looking to get a power of attorney for my mom or dad. Um, and of course, we ask, why do you want that? And you hear, well, they need the help because they can't do it anymore. They need help paying the bills or whatever. I need to get a power of attorney. Uh, so that's oftentimes the type of call, and either directly that or something similar in nature. An adult child is calling up for their parent, looking for assistance. And the first thing is we have to judge whether or not that person, mom, dad, or whatever, senior, has the ability to work with us, ability to have the decision-making authority and functioning to work with an attorney and tell us, like, yes, I would like my child or I would like this person to be able to be my power of attorney, my healthcare agent, or my trustee. So we have to go through an assessment, and this is an assessment that we have to go through as a firm, and it's just important to kind of walk through that so you understand, because this is the legal assessment of the capacity issues. So we kind of go through a triage. When we meet with a mom or a dad or a senior, is like, all right, do what I just talked about here before, how to tell, like, are any of those telltale signs present, because they engender further conversation. So when capacity is intact, it's clear, like, look, I'm talking to a human being that appears well kept. It's clear that they're engaged in the conversation. They're answering basic questions. I can understand them. They're able to recall things I'm asking about that had happened in the past, or who people's names are, and things like that. Capacity is intact. So obviously we can move forward just like as we normally would. So really, when you go and work with a estate planning attorney, just in general, and say you're in your 30s, 40s, 50s, 60s, we're not in that senior category that we're talking about when mid 60s and on. Really, this is going on, but it isn't really as called out and as prevalent, but it's just kind of going on in the background. Because usually the presumption is that you have capacity until you do something that says, "Ooh, I don't think that that person has capacity." And guess what? That's the law. The law is that everybody, no matter how old they are, has a presumption of capacity. So we have to start there legally. Can't say, well, oh, they're subjectively, we believe them not to be able to take care of themselves. But the law says, presumptively they do, and you have to show us and prove that this person does not by clear and convincing evidence. So when we go with that presumption, the presumption is clear that nothing is out there to overturn that presumption, then we can just continue to move forward. We just move forward with that person. However, if there's some things that are questionable, then we have to start to look at taking a pause, because that does raise a concern. Like, ooh, they don't look like they've shaved in a week. They're wearing dirty clothes. They don't look well groomed. They're slurring their words. Like, maybe there's some things there for us to take a look at. It's questionable. So we want to be on guard whether or not they're making informed decisions. And then some surrounding things like who are they with? Who brought them in? Do they seem, are they not being really communicative during the meetings? Do they seem very quiet? And you have this very loud voice, another voice in the room, whether it's a spouse or a child, another family member that is being very bombastic, loud, and clearly is the person that's really driving the conversation, and that senior's just sitting there quiet. Well, that's a red flag too, because we don't know their ability to discern things. We don't know their true wishes. They're not speaking up, and so what we have to do is we have to talk with that senior by themselves. And so that we can get a full picture of what it is that they're thinking and how they're thinking at a minimum. Is it, do they even really want to be there? I mean, one time I had that situation where it was a mom and a son. This was a number of years ago, and they came in for a meeting. And the biggest red flag was we sit down for the meeting, the and mom and son launches off into the a conversation of, mom needs this and that, and mom's just sitting there like this with the gnarliest look on her face, like, I don't want to even be here. Um, so we had to take a pause and politely ask the son to step outside and talk to mom. And mom didn't want to be there. She didn't want to go talk about these things. She's very clear. So there was no question that we're dealing with somebody that knew what was going on. She just felt pressured to being there because the son made the appointment, the son was coming with her, the son was doing all the talking, and she just was not ready to have that conversation, even though she needed to, even though she needed assistance, she needed a plan, all of that. But at the end of the day, she was able to communicate what her wishes were, and so in another situation, that might have gotten overlooked if you're not inquiring of the individual. So that's really, really important. And of course, on the flip side of that, it's important because if alone in the room, that person's still not able to reason, answer questions, there's still red flags. They're asking you who you are every few minutes, then that raises a different flag of whether this person has the ability to even work with an attorney. So we have to flush that out. So, because sometimes with fluctuating capacity, even sometimes people are okay and they're not. Sometimes that has to do with the time of day, with if they're sundowning. When we work with them in the beginning of the day, they're fine, but due to due to the timing of the day, they're not so good in the evening. I know if you try to do a estate plan with me at 10 o'clock at night, I ain't gonna be any very good at that. So my mom would say, "That's not very good English, Kevin." I ain't gonna. Well, I'm not going to be very good about helping myself in that conversation because I'm tired. So we have to look at some of that's just timing of the day, unique to the person. When are they the most effective? So you could have some fluctuating capacity from the time of day or from the condition. So we do have to be careful and do assessments. So what do we do in that situation? We get an assessment. Um, and I'm going to flip through this. And I'll come back to this, but we want to get a evaluation. And my dog believes that too, so you just have to bear with him. So he doesn't want a psychological evaluation. Um, some of my neighbors might suggest otherwise. But here, back to the people, neurological evaluation. So it's important here that these play into determining whether or not, legally speaking, somebody has the ability to make informed decisions for themselves. And again, this is we're not relying on subjectivity here. We're relying on expert opinion. So the types of people who are doing these neurological evaluations are neurologists, neuropsychologists, or psychiatrists. So you're not getting this from a podiatrist. You're not getting this from your primary care doctor. That's just not happening these days because they're not willing to stick their neck out to make those kind of opinions because their malpractice insurance providers are telling them not to do that because why? They're worried that somehow that opinion is going to be attacked and there's going to be a lawsuit and because there's a lot of litigation when it comes to trust in estates. It's a growing industry from a standpoint of there's just more litigious people, but there's just also more people aging and passing away, and so there's more estates to deal with, and oftentimes it's not about the complexity, the size of the estate that we're dealing with. that are engendering the issues. It's the fact that people are fighting over long-standing disputes within the family, and they're exploiting the fact that mom or dad may have had a capacity issue, or there was some real issue where mom or dad did some planning when they really didn't have the ability, and there was some undue influence and things like that. So we want to make sure that we're protecting our planning, not just looking at it from a tax perspective, not looking at it from a asset protection standpoint, but looking at it from a practical lawsuit prevention strategy is, hey, look, let's not give anybody any reason to come in and collaterally attack this later. We're protecting the integrity of the seniors planning by ensuring that there's not going to be an ability for anybody to hang their hat on a capacity argument and say, you know what, mom was unduly influenced into making that trust. Mom didn't know what the heck she was doing when she made those changes to the trust. And so we're going to seek to void them. When all along, it's really mom's true intent to do whatever it is that mom wanted to do. And we want to protect that intent because mom's our client. So sometimes when we have those red flags, we have to look at getting a neurological evaluation to support that. And so this is not this is a decision that's very intentional, and it's not something that's taken lightly either. Because if the valuations all come back that mom doesn't have capacity, then we're going to be forestalled from making. We can't make those changes or updates or new plans that mom may really have wanted to do, and we're stuck going to a different area of law called the conservatorship, which is going to court to get a judge to appoint somebody to act for mom or dad if they don't have any planning already, or to make a change that would be necessary and important on behalf of mom or dad's estate. We need to get the court involved through a conservatorship. Not fun anytime you're going to court. I don't have to tell you it's going to take a long time, and then it's going to be expensive, and you have to get other lawyers involved, and there's at least two, one for the petitioner and one for the senior at a minimum, and so there's two attorneys at a minimum getting billed, and it's not really a great environment, right? So we want to avoid that. So how we do that is by having these capacity evaluations, because now we have proof of one way or the other. But if we say, oh, there's capacity, we have that proof there. Like I said, where there's a presumption, but we also want to have the backup in case anybody challenging later say, hey, we have evidence that would rebut that presumption and show that the senior mom dad is going it does lack capacity because we can testify to this and that, and we have this evidence here. And we don't want to be in a position where they rebut the presumption and then they win that argument. We want to have evidence that continues to support that fact, and hopefully we never have to use it. And they're on the hook for proving and rebutting the presumption first, and they can't even do that, then it doesn't really matter. But we have our ace and up our sleeve, which is the capacity evaluation. So moving right along, going back to those decisions, were there questionable? We need to do that. If capacity is completely lacking, I feel like, hey, look, I can't even talk to this person. They're not even responsive. And I say responsive, I do not mean they can't talk to me. They just aren't able to respond to me, because there's nonverbal ways of communicating, nonverbal cues that we can work around when we have somebody who is not verbally communicative. I'm talking about completely not communicative. They can't write, they can't speak. They're clearly not able to track what it is that you're saying. Then those is where capacity is definitely lacking. And then that's a person that we can't help, as I mentioned, and you're looking at getting a conservatorship. So this all tracks. We talked about the legal analysis of capacity is something we didn't talk about, but what we talked about is getting the evaluation. Now, that's a medical opinion, right? So the segue here is we just talked about medical opinions to support our subjective belief that here are my professional belief that this person has capacity, but I'm not a doctor, I'm not a neurologist. So we have the medical opinion. So professional, now medical opinion to support, which could be totally different from a subjective opinion because everyone looks at things differently. So that's why we need to have that. The legal analysis, though, of capacity. It means that does a person have the ability, when we're talking about setting up a trust and what happens after death, or a will, what happens after death, we're talking about testamentary capacity. Do they have the ability to recognize people in their family? Do they have the ability to be able to communicate on some level what it is that they own and who they want to leave that to? And who do they want to be in charge of making sure that that happens? So they don't have to understand all the legal terminology in a trust, all the little bells and whistles in the trust, the legal jargon in the trust. But at a basic level, can they communicate to me and to others? I know who my children are. I know who my grandchildren are. I know what I have and that I want to give it to them in these specific ways. And this is the person or people that I want to ensure that made that happen. That's it. And so that is what testamentary capacity is. The contractual capacity is even different from that, and that has to deal with setting up powers of attorney because those are like a contract. Does this person have the ability to understand the consequences of the major decisions within the contract? Who are the parties? What are they agreeing to? What are the consequences if certain steps are taken or not taken? That is contractual capacity. So we have to take a look at legally whether the person has those two levels of capacity in order to complete a full estate plan. So, and that could still be somebody that's not able to drive, that's super forgetful, that does repeat themselves, that might subjectively be viewed to a number of people as lacking capacity, may even have a diagnosis. And that's an important key piece here to remember. Even if the senior has a diagnosis, your mom, dad, whoever has diagnosis, does not mean they lack capacity. It just means that they have an illness, a disability. They've been diagnosed with Alzheimer's, they've been diagnosed with Parkinson's or other form of dementia. That just means that they've had an identification of an illness and then maybe where they are in that stages of that dementia. Is it early onset? Is it moderate to severe? Is it severe? So, or advanced. That's the terminology. So it's they have this, and this is where they're at in that journey. So that doesn't mean that the doctor's saying they can't sign legal documents. That's where the legal analysis comes in. I will tell you, it becomes a lot more difficult if the medical opinion is they have moderate to advanced dementia. That's more difficult of a situation than early onset. So here, the call out is, look, if there is a diagnosis, then the next step you take out of the doctor's office is go see a trust and estate attorney to assist with the planning because you have that small window still. And everyone's journey through dementia is different. And so, oh, my friend's mom, it was a number of years that she had her Alzheimer's, and it was a slow progression. Another person, it was rapid. So we don't want to waste time here. We want to strike with the irons hot, and okay, meaning, while mom and dad still have that window of ability to make these types of decisions, we want them to be able to get planning in place if they don't have any, or review the planning they have in place and ensure that it's updated to their wishes that they need. Um, and so that's a huge call out. Or if they need to do things like they had a spouse that died and they never updated their plan, that's an important thing to do before they lose the capacity. So we talked about what capacity means. Moving on to these documents, all right, these legal documents. Here, the importance is with capacity is that we just understanding what that gets you, right? So what kind of powers are your mom or dad, other senior loved one going to be bestowing on you or others in the legal sense? So this idea of power of attorney gets floated out there, which is why I'm calling this out right now. So it's common to hear, well, I have power of attorney, or I want to get power of attorney. But what does that really mean, power of attorney? Legally speaking, there is not one universal superpower attorney. That like kind of like my Ren Spooner here. I got some superheroes. There isn't a superhero power of attorney. Not one universal document controls everything. In the classic sense, there are two types. There's the financial and then there's the medical. So on the Financial side, those commonly referred to as durable power of attorney. On the medical side, it's a medical power of attorney or it's a healthcare directive. So in California, we call it Advanced Healthcare Directive. That encompasses the medical power of attorney. You have a person called an agent that has the permissions by you to make medical treatment decisions during your life and after your death of what happens to your person. On the financial side, it's called an attorney in fact or a power of attorney agent. That person has the permission from you to make financial and legal decisions on your behalf. They stand in your shoes. So when it comes to that's what the basic level, there's two areas. And then within the financial area, there's different types. There's an immediate, and then there's a springing type of a power. The immediate means like right now, you have co-occurring authority to make decisions on my behalf. So I might give that to my wife, who can then go to if I have a separate account, she can go to the bank and be able to access that account, even though I'm not there because she has a document that says she has immediate authority. And I don't need her to go run off to a doctor to get an opinion that I lack the ability to make financial decisions for myself because I trust my wife, right? And so that's somebody that I don't want to have to waste time of going to a doctor to get a doctor's note to get this legal authority. So I make it immediate. And so some things to think about are do I want people to be immediately acting for me, or do I want to have that condition? And I think for by and large, a lot of us say, "Ooh, if it's not my spouse or whoever it is that's like really the next person I trust implicitly in my life, maybe I'm younger and that's my parent, or married that's my spouse, anybody else, I don't really want them to have immediate authority. What if they go raid my bank account?" Well, number one, if you really trust them and they are trustworthy, they're not going to do that. So the first order of business is really thinking and considering who's going to be named to give this power. The other is, do they have the power now? So if you're giving a succession, you're saying my wife, and then if not my wife, then the next person. Well, that next alternate agent doesn't have authority while your wife's still alive and has capacity. So they can't go run off to the bank. So if you got an argument with one of your best friends, or it's a sibling that you put in that category as alternate agent, they can't run off to the bank and raid your money out of spite because they're not the first in line, number one. So there's still time to make those updates. Number two, you already consider that they're not that type of person to do it anyway. We want to think about barriers. Like what kind of barriers do we want to put in place for these people to act for us? We've chosen them to help us. So do we really want to put a barrier there of going to get a doctor's note? Because the reality is that because the concern boils down to this. Well, I don't want somebody to just say I'm incapacitated or act for me when I don't want them to. Well, if you have capacity and they're acting and doing things that you don't want, then you're going to get a new power of attorney that deletes the old one. And so you're going to remove them. You have the authority to do that. Or if they somehow you said, well, they got a doctor's note saying some quack doctor, right, rogue doctor that got an opinion said that you were incapacitated, you always have the ability to go get evaluated yourself to have a competing opinion. Guess what? Your competing opinion wins. So you're protected from that sense. So the way I kind of looked at it over the years is I've seen too many issues with barriers where we have good people who are agents ready and willing to step in, or successor trustees willing and able to step in and could really do some help, are handcuffed because it takes time to get into a doctor's office. And never mind if you have that condition of two independent physicians, which is the default in the California law, and often a lot of trusts have that old language in it. Two independent physicians, or you see that in powers of attorney. Sometimes it's even worse. I've seen, no joke, three independent physicians, and one of them has to be the head of the medical association within the county in which they work. Like that's impossible to find those people and meet those conditions. So now all you've done is create a situation where people have to go to court and seek appointment to be a conservator. So again, we don't want that. It sounds really nice. Oh, I'm protected. No one could falsely accuse me of having incapacity. This is not the Angelina Jolie movie, The Changeling. No one's going to institutionalize you that because you vetted the people. Those are the people that you want to help you. They're going to come in and want to help you. So um, then we don't want to put barriers. But Kevin, I've heard so many problems with kids raiding mom and dad's account, or I know personal experience, my brother or sister did that, or blah, blah, blah. Those do happen, right? What's the problem? Problem number one is there wasn't a good vetting process. Problem number two is that there wasn't an updated, continuous vetting process because people do change. True colors come out or they get influence. You know, my daughter was great until she married that guy, and that guy has just been such a bad influence on her, and she's making all sorts of bad decisions. And now he's convinced her to it's okay to just kind of take mom's money and we'll pay her back, and or to the point that there's been some rift and I never updated anything. And so, or I got divorced. And I tell you, this is true. There's not a lot of updating. So you have to constantly be looking at and updating and re-vetting these people that you choose. Because the truth of the matter is, even if you have the conditions in there that you have to be deemed incapacitated, well, what if you are incapacitated? Those people now have authority and they're not the right people for the job. So it starts there. And then if you engage in that process of continuously evaluating who you're choosing to be your decision maker, then you can feel comfortable that maybe I don't want to have that barrier of them getting this doctor's note. So that's with the powers of attorney. And that with medical, it works a little different because doctors are always going to listen to the patient if the patient has informed consent. So it doesn't matter that you have the agent there. Doctors saying, look, Kevin can talk, Kevin can communicate with me what his wishes are. He's understanding what I'm saying about his medical condition, all that. He has conformed to consent. I'm going to follow what he has to say, despite what his healthcare agent might be chirping over here saying should be done. And then lastly, with the trust, it works differently because the trust, it's either you're a trustee or you're not a trustee. So you're a trustee or a co-trustee or you're not a trustee, right? So to be a trustee in the situation where, let's say I have a trust, I've designated my children to be the successor trustees. Uh, I can't have a situation of immediate trusteeship for them unless I want them to be immediate trustees now, right? So in order for them to be trustees while I'm still alive is that they do need to show that I've lacked capacity or I've appointed them to be co-trustees. So if I've appointed to be the co-trustees, great, right? Capacity to do that. There's a document we sign and notarize. Now they're co-trustees with me. Or I've bowed out, I've resigned and appointed them. But other than that, for them to act, and I've named them to be successor trustees under me, one, two, three, they have to show that I'm incapacitated. So we have to be clear on the standards that we're using and not making it difficult. So again, all of those things where we have all these onerous conditions, we really got to think it through. How is that going to play out? We got to get multiple appointments. What if dad didn't have a neurologist? We got to get that one, and we got to get a second. Now we're talking about 6 months easy before we have two opinions that could realistically be relied upon. So we have to look at all of that. So the consequences of lack of capacity, I mentioned you end up in court if you don't have your planning. Now, if you have your planning set up, conditions met, lack of capacity, whoop, then your next person that you've given permission to be your decision maker steps in. So this planning really makes the process easy and smooth. If you're doing it right, doing it early and often, and you're re-looking at it and reevaluating, then the right result happens, no court. But if you're not paying attention, you don't do the planning, something that would otherwise be pretty easy to do creates this huge problem, because now you're going to have to go to court, or you have the wrong person in the job, and that creates issues. And then guess what? It might be end up in court anyway, because then another family member is suing that decision maker who made a poor choice and management of your money, ran off to Vegas, or did poor investing, or was just negligent, didn't pay attention, didn't really care. All those things do happen. So that's when court gets involved. So we want to avoid that. So as mentioned, our estate planning tools, we use power of attorneys, durable power of attorney, advanced healthcare directive, and we utilize the trust, because the trust is going to deal with a trustee being in charge unless they don't have a capacity, or The person who created the trust died. Now we have a trustee stepping in. So a trust works in life or death, dealing with capacity or death. We talked about a durable power of attorney. Lots of different types of powers of attorney. Just to put a cap on this, durable power of attorney is the most common. Why? Because it's durable, meaning that you create it when you do have capacity, and then it remains valid despite later you have been determined to lack the capacity. It doesn't invalidate the whole document. Now, I don't know why there was ever a power of attorney that existed, but they came up with a durable version, and that is the standard, right? So if for some reason you don't have that durability language in your power of attorney, then you need a new power of attorney, full stop. But there's others. You can do a limited power of attorney, be when it's just for a specific thing, like sell my house, sign my contract. I'm going to be away on vacation, and you can do these things while I'm away. Those are limited types of power of attorneys. The a wider general power attorney is someone can do anything that you can do. So you can have anywhere in between. We talked about immediate versus springing already. So things that come to mind were some arguments and things where things go south with capacity before we move on into Medi-Cal is just family dynamics. So family dynamics are probably the number one issue that causes litigation. No, and we're talking about litigation after someone dies to litigation while our parents, other seniors are alive, and it has to do with family dynamics from a standpoint of how are the the children getting along with each other? How's the parent getting along with the children? How are the spouses of the children getting along? What is their relationship with the child? Is it a bad marriage? Is it a difficult, challenging marriage? What's the spouse like? The in-law like? What's the relationship of the in-law to the parent? And how do they interact with the other siblings? That whole family dynamic, because this in-law came in. Sometimes that's the issue. Sometimes it's the deep-seated resentments the children have with each other or with their parents. From earlier on and growing up. Maybe it's the condition that the parent has creates a lot of dynamics within the family, or the professions the children have. Oh, well, they're in the medical profession, they're in the nursing profession, they know best. They lord their opinion over, or they're not respected for some reason, or there's another just person in the family that is the know-it-all. Or oftentimes we see this, it's the out of town child that seems to take the more power position. Maybe it's because they feel that they're so far away, they don't know what's going on, and so they're suspicious of everybody else, or they feel like they know best. And the in-town person has the target on their back, or there's resentment that, hey, look, I do everything for mom or dad, or mom and dad. They don't do anything. And that resentment isn't from deep-seated things from growing up. It's more now. Sometimes it connects the two periods of time. Oh, this is just how they were like when we were kids. They always would go to the bathroom when I was doing the dishes, and now they moved away to North Carolina and left me here with mom and dad, and they only have an opinion when it's convenient for them. But otherwise, they leave me to do everything, and they want us to do this, but where are they every other day of the week? That sort of stuff. Why is that so easy for me to talk about? Because I hear it every day. So it doesn't mean that your family is going to end up this way or you're dealing with that. These are just common human nature things that we have to consider when we're dealing with capacity. And then the individual parent, sometimes the dementia manifests into anger, outbursts, obstinance to downright, physical reactions. I had a couple clients that were alcoholics and been sober for decades and that started drinking again. So how do we manifest that? And some of that trauma also plays into the dynamic. Well, remember when dad was an alcoholic growing up and he'd been sober for 30 years, but now he's got Alzheimer's and he's drinking again. And all that trauma from when I was a kid or trauma from when we were first early in our marriage comes back, right? So we have to work with that. And then in the basic stuff, just parent-child fighting over the switch in the relationship. Now, the child's really the parent. The parent's the child. Well, no, you shouldn't be driving. And oh, I'm going to drive. You can't tell me no. I've been driving longer than you. Well, it's not safe for you to drive. So those are things and practical issues we have to deal with. Professional fiduciaries are really great to step in to mitigate the dynamics, either during life or build it into the planning. So when you're incapacitated, now we have the fiduciary stepping in instead of a child, or they're co-trustees with the fiduciary, even after death. So a lot of times fiduciaries are really great to minimize the family dynamic that's really going to blow up things. Um, so we talked about these things, and that's we're concerned when it comes when a fiduciaries can not just be for, okay, I'm going to take over and be the legal decision maker. They also can help on the day-to-day things like with bill pay and just keeping your senior organized, so that there aren't any financial or legal problems just because they've gotten disorganized. So, and a lot of times it's helpful because now you have a neutral party because the senior doesn't want to involve maybe a child or a niece or a nephew because they were more private, and so they don't want to do that, or they don't want them people to realize that maybe they're disorganized. So they're really close to the chest, but everything's a mess. So having a neutral third party in there oftentimes works from that situation. So now shifting to other things to be worried about and supporting seniors is paying for stuff. So how do we pay for stuff? The costs of care in California are astronomical. Across the board, all across the nation, they're expensive, but certainly here in California, very high cost of care because there's a high cost of living across the board. So this is a number here. I know it's true, but the data here, we have the footnotes, but it seems that this is low. We're talking about $6,101 per month on average of in-home care costs. It seems like that's low because people, need more care. They're living longer. There's really good in-home care options, but it costs money. Particularly if you're doing 24/7, you can expect $15,000 at a minimum to upwards to 40. If it's 24/7, 7 days a week, you're up there to $40,000 for in-home care. Then if you shift to care outside the home, again, I think I just get this feeling that these numbers are getting a little outdated. $4,500 per month on average for assisted living just kind of depends, like where you are on that scale of is it really good or not. Um, we we want to take a look at where it is, the options is assisted living facility with memory care. That could be 12 to 15,000 a month. And it's in a nicer place. Is a boarding care community, which is those residential homes with six people in it that are being cared for. That might be a better fit. A lot of times those are less expensive, but they might not meet the care. So working with a placement advisor, if you don't know what that is, it's a person that professionally could help you find a good place for mom or dad. So you may have heard of A Place for Mom, which is a company that works as a referral system. So you can go to their website and they'll basically take your information and farm it out to some placement people to kind of pick and choose like a lead generator. But literally, Place for Mom, Place for Dad, these are not companies I'm talking about. I'm just talking about we want a place for them. Aunt, uncle, senior, we want a place for them. So there are professionals that do that, that help you find the right fit. So that's a great place. We have great referrals. We have good referral partners there that we refer to our clients to get the right placement, but it's going to be expensive. So how do we pay for it? Well, we private pay. Number one, comes out of mom and dad's wallet or the kid's wallet. We look towards long-term care insurance. A lot of people don't have that. They should, that's a great idea. So getting long-term care insurance is super great. You're in your 40s, 50s, 60s. Now's the time to do that because that's going to be one of the first lines of defenses, as having that insurance help pay for the long-term care. Will it pay for everything? It may not. And if it doesn't, all right, well, it paid for a whole bunch up front, so that didn't dip into your savings. So it's always going to be a benefit. In my mind, we preach this with our clients that are in their 40s, 50s, and 60s, even 70s. You never know. You might as well get the information if you're not qualified. Don't just assume or assume it's going to be expensive. We have really great partners in that space too. But okay, so we private pay or we have long-term care insurance. And usually the order is different. You have long-term care insurance that goes first, then you have the private pay and you're paying yourself. Or if you run out of money, you have Medi-Cal is an option for people if they're impoverished, they spend all their assets, they have Medi-Cal to help pay for skilled nursing, not assisted living, but skilled nursing is different. Higher level of care when you need medical and custodial care, skilled nursing. So there's a gap. So people like, oh, I'm not skilled nursing ready, but I don't have any money for care. Well, what happens? Well, now we're cobbling together care. Maybe we're living with some family, and that makes it tight, uncomfortable. It's not ideal. You're living with friends, for example. Um, so or you're at skilled nursing and you really shouldn't be there because you went there and transitioned after an operation from the hospital and you're rehabbing there, but they can't discharge you anywhere because you don't have any money to go and you have nowhere to go. So those are really sad stories. But there are solutions. So we can use Medi-Cal for our benefit. We can use VA benefits for the benefit. But the challenge for people is that the laws are changing in Medi-Cal. So this could be a whole separate conversation, whole new webinar that we will, I'm sure, be setting up in the months to come. The big beautiful bill is slashing Medicaid, so it's just a trickle down. That means less federal dollars to the state of California, which means there's less money for Medi-Cal, which means that California, in protecting its budget, has to do what? We can't service as many people on Medi-Cal. Well, how do we ensure that we're not servicing people on Medi-Cal? Well, we're making sure that not as many can sign up and get it. So before we were doing the Medicaid expansion. And remember, Medicaid is Medi-Cal. Medi-Cal is California's Medicaid program. So Medicaid expansion, we let more people come in. So what do? We said we're not going to count how many assets you have. So no asset restrictions. We're just going to look at your income. So more people were eligible, but now we're going to have to restrict it and kind of clamp down on the spigot of the Medicaid dollars. So we're going to say for Medi-Cal, we're going to restrict it for only people that have less than this amount, and we're going to put back these asset limitations. And that's as coming January 1st, 2026, there's going to be a hardline rule. If you have more than X amount in your estate for assets, you're no longer getting Medi-Cal, you're no longer eligible. This is going to be a problem for some of our seniors that are in skilled nursing right now. And the reason why they got qualified is under a no asset rule. And they have assets that will otherwise disqualify them. Those people need to act now to do their planning. Good news is we're still able to do some planning right now before January 1st. That can be done quickly, and they don't have to sell off their assets or give it to their children or spend it all to get qualified. We can safe harbor them with estate planning, utilizing special types of trusts to do that, and they will not get kicked off of Medi-Cal. And it's come January 1st, now or come January 1st. The next category of people that want to be proactive and like in the future, I want to make sure that I am qualified for Medi-Cal and I don't have to spend down all my assets to qualify for it. So I want to do this planning so that I'm going to ensure that if I live a long time with Alzheimer's, that I always have the standard of care that I want because I didn't have to spend all my money first and then get Medi-Cal. I can combine the two to help me stretch out my financial runway to pay for care. Never mind, I have maybe a desire to leave some sort of inheritance for others. Or a need because maybe I have an adult child that has a disability and I want to make sure that I'm not spending all my money on me during life, that I'm leaving something for them because that would be helpful. But the number, we just don't know what the number is going to be. They say 130,000, and that's not that high. So, and that excludes your primary residence. But what happens, people, right? We know that we have to sell mom and dad's house to pay for care. And once we sell mom and dad's house, that house becomes cash. Now that cash is going to be more than 130,000. So we have to do some planning up front before we sell any property to do anything. If you take away nothing from this conversation today, it is do not sell mom and dad's house. Do not sell the senior's house before talking to an elder law attorney. What's an elder law attorney, Kevin? Well, an elder law attorney is an estate planning attorney that has experience working with seniors and that understands Medi-Cal, understands VA benefits, has that experience doing the planning to qualify those seniors for that, dealing with the capacity issues we talked about. That's all what falls under the umbrella of elder law. Sometimes those attorneys deal with conservatorships or litigation. Those are other areas of elder law. What I'm talking about right now is benefits planning is super important when it comes to elder law. So you want to speak to an elder law attorney before you sell that house, so that you can ensure you're thinking you're doing a good thing, but really doing your mom or dad a disservice, or doing the senior a disservice because you sold the house too early without the protections. So guess what? We can sell the house, not a problem. With protections, wonderful. Now mom and dad can still qualify for Medi-Cal, still get the VA benefits, and they still could sell the house. So we just have to do it the right way. And there's going to be more of that because of this change of law right here, because the asset threshold's so low. It might even be as low as $2,000, which it is in a number of other states. It is for SSI. Um, for those of you that understand or know someone who gets that disability benefit, that's the threshold. It is that way in other states. And that's a federal rule, so it could the federal laws could get imposed on California. In case you've been paying attention, the federal government doesn't really like the California government right now, so they're at odds. And if there's any way the federal government can impress and impose itself on the California government right now, they're taking that opportunity, and this is just going to be another venue for that. So I fear that the threshold is going to be as low as 2,000. And that's not a far stretch. So the whole point is that there's going to be a ton of people that are currently getting benefits that are going to become ineligible if they don't take action now. And there's going to be more people that are going to need this benefit that aren't going to be qualified to do it later if they don't be they're not proactive. So, and the types of assets that we're going to be concerned about people having is selling the house, as I mentioned, but brokerage accounts, qualified accounts like annuities and IRAs. You have more than one property. Remember you bought that starter home, you never sold it, and you kept it as a rental property or as a family property. You have that house in Lake Arrowhead or down at Balboa or up in Lake Tahoe, whatever, and it's a family vacation home. That's a problem. We want to keep that as a legacy property to pass down to our children. But now we got to burn it because we got to pay for our rising our assisted living costs and everything, or skilled nursing, and we could have leveraged another benefit, but we just didn't know, right? So again, this is the important proactive planning and crisis planning that we can help with. I'm going to skip over assisted living waiver program. Just know when you're talking to the placement advisor I told you about to help you find a place for mom or dad, this is something you might want to talk to them about. A special program to leverage Medi-Cal for assisted living, because normally Medi-Cal is just for the skilled nursing, which is the acute care places where you generally go rehab after you get discharged from a hospital, but it could also be long term. Um, oh, well, I will say this before we hit the last parts of this conversation today. Just because I love In-N-Out. And who doesn't like In-N-Out, right? But did you know that the In-N-Out owners, they're also the Snyders? And you're here at Snyder Law, and the Snyders have In-N-Out. Is there a connection? No, just that this Snyder likes In-N-Out, but I'm not related to them. The point here is that Medi-Cal is kind of like going in and out, right? So, and in the sense that there's only a few options and buckets you can get to. You got your, I want a number one, number two, number three. There's not a lot of wiggle room, very strict rules. So very much like In-N-Out there, that you can't, you got one or two or three. Unlike In-N-Out, there's not the secret menu that you can choose from, but there are secret rules. And if you know the secret rules, then you can get stuff that you might not otherwise get from a one, two, or three. So in that sense, it's very much like In-N-Out. You go to In-N-Out, you can get the animal style. You can get the 3x3 or 4x4. Totally saw one guy get a 4x4. Oh my gosh, that's amazing. I don't know how he finished it. You can get the Neapolitan shake. You can get the animal style fries. You can get the Flying Dutchman. All that. When it comes to Medi-Cal, if you know the secret menu, you can qualify for other things, like having Medi-Cal pay for a bulk of the care and then supplement on top of that. So you get the base level of care and then pay privately for the upgrades, and it's a lot cheaper that way. So for people out there that are veterans or they have veterans in their life, like I do with my dad, I'm thinking about benefits for veterans. And the number one benefit that's out there that gets overlooked is aid and attendance. People hear veteran benefits and they think I need to have a service-related disability. I need to be wounded in battle, I've died, and there's some benefit there for spouse and family survivors. To I now have a service-connected disability like PTSD, or I have some cancer from exposure to Agent Orange. There's some I have a screwed up back because I was a pilot. I have bad hearing because I was on a flight deck or in a tank unit. There's those are service-related disabilities that don't manifest till later in life, and there's a causal connection. When people see VA benefits, they think disabled because of service. There is that, and that's an important piece to how we help veterans. But there's this overlooked piece over here is like you can be disabled and it has nothing to do with your service. But it's important you did serve because we're going to help you out financially. You can get up to $2,400 a month, approximately. There's a little extra change there, but the point is that if this you have a senior who's a veteran and they served within certain wartime periods, so just we have to be specific, we have to take a look at it, but just in generally, World War II, Korea, Vietnam. All right, there's some points in there that might not qualify. We have to take a look at. When you were in a service, Army, Navy, Air Force, U.S. Army Air Corps, Merchant Marines in World War II. You're in the Coast Guard, Space Force now. Although we're talking about these wartime periods, technically we are in a wartime period now, so Space Force would count if you needed this once you're 65 and older. So in the future, people that are in Space Force now, they're 65 and older, can qualify for aid and attendance. So you need assistance with activities of daily life. You need two of them: transference, toileting, eating, bathing, moving around, transference, moving around the house, or transportation. Then and eating could just be like meal prep and stuff. So these are activities of daily life. You need assistance with any two of them. Easy one is transportation. You don't drive anymore. You need someone to drive for you because it's unsafe for you to drive. You got one, and you just need one other one. You can qualify for this benefit and get up to $2,400 a month. That can offset your costs. And guess what? Your costs then can help you get qualified as well. So I could get into all the algorithms and the math about this, but just the call out and the takeaway is the in-home care, the assisted living, skilled nursing, or boarding care, those costs of your care to care for your senior can help get trigger this benefit for this aid in attendance. So don't ever think that you have too many assets or too much income to qualify, or don't let any a senior parent or relative tell you that. Take a look, have a conversation with a VA accredited person. I am one there, and you can go and check out who else is in your area by going to the VA website. But they have to be VA accredited to, number one, make sure you're getting the right information, but number two, assist with the application. So we need to apply for this, and it's free to apply, so no one can charge you for the help with the application or the submission of the application. So if someone's saying that they will charge you for that, that's a red flag. Um, so this is something that we help clients with, families with, so they can find some money. And then also we're looking at compensation sometimes. The VA has, so here are the actual rates up here. Um, like I said, I'm going to go over some of this stuff, but they have a caregiver program. So let's say we have my parents. My mom could apply as my dad's caregiver and get up over $2,000 a month. Of course, there's some rules in that, but now we have to have a service-connected disability of 70% or higher. There has to be evaluation. But it's important to take a look at because that might be extra money and that doesn't deduct from what the veteran receives. That's in addition to. So, you can get a veteran household can get anywhere from $2,400 to yeah, they can get 6,000 plus. So, very, very helpful for cost of care. So a lot of that is all to say, because in the interest of time, we want to make sure that we take a look at this, but don't get fooled by, oh, there's a look back period. Oh my gosh, that means this and that. It's 36 months for VA benefits. It's 30 months for Medi-Cal. Forget the 5 years. If you have 5 years stuck in your head, forget about it. It's not 5 years for any of this for veterans in California or seniors in California. But we do want to do it right because if we do it wrong, there's penalty periods and all that. So that we talked about today, that's in here. We're chock full of information. We really compressed this because it's an important topic. We could have taken each of these and done our own presentation, and Laura's probably listening, going, "Yeah, we're going to do that." So stay tuned. We'll take a deeper dives into some of this as we go forward on these lunch and learns in the future. Thank you, Laura. Thank you for everybody for your attention, and have a wonderful weekend and keep being amazing.